hearsay. Let's talk about it. Does anybody really know what it means? I know we hear about it on TV or in movies, and people bring it up when they're being drama queens or gossiping or being chismosas, and they're like, I never said that. That's hearsay. So, Playboy, what does hearsay mean? Okay? I'm going to use a little bit of a cheat sheet because I don't have all this memorized. But the legal definition, according to the federal rules of evidence, hearsay is an out-of-court statement offered to prove the truth of whatever it asserts, which is then offered in evidence to prove the truth of the matter. So what does that mean? Well, first off, there's two types of hearsay. There's verbal, and then there's documents and such. So let's talk about verbal. It's an out-of-court statement. It's something that was made not under oath, so not in a formal setting. The person wasn't sworn in, nothing like that. So it's something that somebody else said, right? And that person that said it is normally not there to testify to it, be cross-examined to it. So then it becomes hearsay. So why is hearsay not admissible usually? There are hearsay exceptions that are admissible under the rules of evidence, but why is hearsay usually inadmissible in court? Well, it's because it's not very reliable. The person's not there, the document's not there. Sometimes the original person, they can't track them down, somebody has died, or it's because it's a rumor. It's something that somebody who wasn't even present witnessed or somebody heard about. It's something that shouldn't be really brought in to prove the truth of a matter therein. So that's hearsay in a nutshell. Now, what are the exceptions? Well, there's many exceptions, but I'm going to tell you my favorite exception under the federal rules of evidence is rule number 406, which is habit evidence. So sometimes under a person or an organization, excuse me, I can't kick this cough, habit evidence can be brought in as a hearsay exception. So what is a habit? So let's say Mrs. Jones walks her dog Sparky every day, no matter what, rain, sleet, shine, sunshine, snow, no matter what, every day at 7 o'clock going down Market Street. Every day, no matter what. That can be brought in as her habit evidence. That is her habit. That she does that no matter what, every single day. She's done it every day for 25 years. So if there was a scenario in which they need to prove that she was, I don't know, I guess there on Market Street at 7 o'clock every day, that could be brought in under FRE 406 as a hearsay exception. Hit me up if you have any other questions about hearsay. I want to start explaining simple legal terms. Well, they're not so simple if you're, I guess they're not even so simple for lawyers, but legal terms that I think everybody should know. Hearsay is one of them because it's kind of something that it does take a whole semester to learn, plus a million exceptions. But I want to make it easy for the everyday person to know because I believe that we should all know our legal rights. We should all know the definitions, our rights, things that, people of the United States under the Constitution, it is your legal right. So FRE 406, habit evidence, is a hearsay exception. And hearsay is an out-of-court statement being brought in as a truth therein to prove as evidence, but normally is inadmissible unless it falls under one of the hearsay exceptions. Hit me up in the comments if you have any questions or if you want me to cover any other of the hearsay exceptions.